more of these will go very long when it's anticipated. You know, for witnesses, you're talking 15, 20 minutes on direct, 10, 15 minutes on cross for 4 of them. Maybe there's more, maybe there's 5. And I don't know how many people, but you know, there's 6 appeals if there's 1 witness per each appeal. And so that, yes, we can do it earlier. My belief would be, I do a lot of work in Henderson County, and they put a 4-hour limit on their hearings, and those 4-hour limits have run over into 6 hours. And so when you start a hearing at 4 o'clock and you're still going at 10, they've worked all day, you as the lawyer have worked all day, everybody's worked all day, 10 o'clock is way too late, right? So a 4-hour time limit is good. That may mean you would need 2 or 3 days for these hearings, because nobody is paying attention after 6 straight hours of a hearing, even if you start at 4 o'clock in the afternoon. Come 10 o'clock, you haven't eaten. It's a mess. Yes.
We got it.
Perfect.
Okay, sorry.
Yeah, no worries. We're all good.
Board of Adjustment for Buncombe County.
Is there-
9.5-hour day one time.
Yeah, I remember going to 1 o'clock in the morning. It's a long day.
Oh yeah, no, I've had 7
I'll bring my
a.m.
Well, we
resignation
started at
letter.
noon, and we voted to finish it that day, so we didn't have to come back again. But 9.5 hours was a long time.
And will there be legal counsel that also gives us direction about how we need to interpret based on,
Yeah, so
in addition to the other?
we'll get back to the dates in a minute, because that's an excellent question. Yes, they are legal counsel. You'll have counsel for the appellant. That is the person who appealed the decision. They will have legal counsel. If it's not the property owner, if the appellant is not the property owner is going to have legal counsel, or that legal counsel may be the developer. They'll have legal counsel. Staff will have legal counsel. You all will have legal counsel. Every one of those other legal counsels are going to try to persuade you as to how you should rule, why you should rule that way. Your questions to me aren't, how should we rule, Brian? It is procedurally, what does this mean? What are they asking us to do? Can we do what they're saying, right? You may ask, well, if there's 2 reasonable interpretations, how do we decide that if we think both of them are reasonable? And I will tell you, in all of your appeals, the courts in North Carolina, and the legislature has drafted statutes in North Carolina to allow for the freest use of property. They don't want to tie a property owner's hands. And so again, if you're looking at 2 reasonable interpretations, your duty by statute and case law would be to allow the freest use of that property, right? And so that's important, just because that's what
That's critical.
we are a property rights state. We like people to fully utilize their property, and zoning regulations are a restriction on your free use of property. If you've got 10 bundles of property rights for your property, zoning takes away one of those sticks in your bundle. And so the courts strictly interpret, the prohibitions that the prohibitions that zoning entails. So that's in general for appeals. We'll talk a little bit more about it, but I think you may have asked, or somebody, how long will this take? It might take a couple of days, a couple of hours. One of them may be very quick. We got 6 of them, but 5 of them may be very long. And so I was asked, this is where we left off when Marie informed us that Facebook's no longer live streaming. I was asked to kind of put together 2 sets of 2 or 3 days together, and so that they could potentially, if one day we ran over, we could have the next day already on everybody's schedule to come back. And if there's 2 sets of appeals,
Sorry, guys.
come on,
I had so many things going on today, I forgot about this, and it was on my calendar and everything.
well, that's all right, I'm glad you brought your calendar with you, we had a quorum, so we moved on.
Oh, good, okay,
Yeah,
that's even
so
better.
We weren't waiting on you.
Okay,
But we
thank
haven't
you.
done anything of substance yet. So 2 or 3 days in 2 groupings is what we're looking for. And so we can jump right in, so I'm glad you're here.
Okay.
May I ask, is that the expectation that all 4 or 6 days will be
I
used?
didn't know.
No.
Or is it just one of the weeks, one of the groupings we expect to be used?
So schedules change, issues happen, and so they suspect that, or I suspect that in a grouping, if we have 2 days in 1 week, that maybe 2 or 3 of the appeals would get heard, and then the balance would get heard in the 2 or 3 days that we have set for the next week. If we're lucky, we may get all of them heard in the 1 week. But I have no idea how long this is going to take, and they have no idea how long it's going to take. Several of them might be easy, might just be complete legal arguments that somebody makes that says, the law is interpreted this to mean blank. We are asking them to do exactly that. There's no ifs, ands, or buts about it. The decision was just wrong legally. And that may be it.
Will we have that information ahead of time, or we can't?
So,
What their appeal is?
Yep, that's an excellent question, and we talked about that, and the idea is all parties have indicated a willingness to let the board have information ahead of time, but not piecemeal. And so John Henning, the town attorney, who'll be acting as the staff attorney, is trying to put together what we're gonna call the record. And the record is all of the documents that are gonna be necessary from the staff's perspective as to what happened, when it happened, and all of that. If all of those documents can get together, and all of the documents that the appellant and the property owner or the developer want, if we can get all of that together, they're going to send it to me, and then I may be able to distribute it to you ahead of time. But because, as I was talking to you earlier, we can't have any ex parte communications in a quasi judicial setting, to have it come to you piecemeal is inappropriate, right? The staff report always comes to you piecemeal, but that's not advocating one way or another. That's just saying, hey, the property is located here, it's identified by this pin, it's accessed by this road, it's in this zoning district. That's really your staff report on something like this. But so, yes, you may be getting something earlier, but you might not, because I haven't received anything from anybody saying, hey, we've got the record together, get all the other exhibits together.
Brian, can you explain to them what that record looks like? It's like a big binder with a bunch of tabs.
Yeah, so the record can look like a bunch of different things. Like Shannon was saying, a lot of times it may come to you in a binder like this, that when you open it up has tabs, right? And the idea is that you have the binder here and you look at the tab that is being introduced and nothing beyond it. Again, because if you go, I wonder what's behind tab 3, that may influence your decision. What's behind tab 3 may never get introduced, may be objected to and excluded from your view of it. But the tab comes, the binder may come to you all like this, so that people, lawyers, aren't up and down saying, I'm gonna introduce exhibit number 1, hand it all up, I'm gonna introduce exhibit number 2, right? It helps it transition. But
But
it's,
that would be something that would be that day then, not.
that was the question, and all the parties said, if they can get their act together to get this binder to me, then I could distribute it to you.
On the day of, not in advance for us to read through it all, because you're telling us we can't read beyond tab 1 anyway.
Correct, right. But this would be in coordination with all of the councils to say, yes, we do not mind if they see this ahead of time. I do not mind if they see this ahead of time. right? So that's what would come to you.
As long as we're not discussing it.
You guys can't discuss it amongst yourselves or community members, right? And nothing that's in those binders should influence your decision. It may make the hearing go quicker, right? Because you'll know where the property is, you'll know what zone it's in, you'll know what their appeal argument may be, right? Because in their application to appeal, it may be, list the circumstances under which you believe you have authority to appeal. You know, this may be and this is just what we did the other day, this is a minor co-location on a cell tower, and they've made the determination that because it's an emergency generator, it's not part of the facility, and therefore it's not a minor co-location. You know, that would be what you would write in the appeal. That's not designed to influence you. The attorneys will try to elicit testimony, facts and evidence, and/or opinion testimony from experts. That's going to be designed to influence your decision.
So I don't know if it would help, but I would think that anything that they can agree to prepare and provide ahead of time is only gonna help two things. One is the speed of the meeting, which, you know, that's a minor thing. A better decision, I think, is what that would help. For me anyway, rather than sitting here going, okay, I need to understand all of it at once, but if you could read ahead of time and say, okay, I know what we're dealing with, and then be familiar with it, I think that'd be helpful.
Sure, and we can't require them to do that.
Right.
And it's only information that they would all agree would be presented to the board. And the first part of that is for the town's attorney, John, everybody agreed, he's going to put together the record as it relates to the staff, like the prior staff reports, or the appeal application, or the zoning determination that's being appealed. That's gonna be put together, spread out by all the attorneys, then they will supplement it, it will come to me, and if they've all agreed, this is what we don't mind the board seeing ahead of time, I will push it out to you all. But if I don't get it, we can't require it, and you all won't get it. So, what we have we're looking at the beginning of January 4 dates, and as you could imagine, it is very hard to find a series of 2 to 3 dates, which are good for everybody. However, in January.
Everybody says, wait till after the first of the year. Wait till after the first of the year.
Yes.
So
Yeah.
January is not a pretty,
No, January is not. The first available dates that everybody has available, all the attorneys, including myself, that would be available are Tuesday, the 24th through Friday, the 27th. So that's a block of 4. We don't, look at your all schedules and see what it is. We are just looking for a block of 2 to 3 dates
In a row.
in a row.
24th is, getting here at 6:30 is a little tough for me on that day. I can do it if I have to, but,
Okay.
so the 25th to the 27th would work better for me.
And it doesn't have to be at 6:30. Likely, it would be better if we could start at, 2, 3. I mean, if you want to start at 1, I'm happy to start at any time. But you all look at your calendars.
I have nothing on my calendar that week at all, but I'm a realtor, so that changes every day.
Yeah.
But I can block off now and then, but
Yes.
I'm open those 4 days for times.
I'm an evenings only kind of guy.
I think it-
26, staff would have trouble the 20th, the day of the 26th. Would it be okay?
what's the earliest?
Okay, and when you say
When
the
could
day,
we
what time
say
does
6:30?
Probably
that
5.
day end? Like 4?
Should go as
I
early as-
think after 3, 4 o'clock, we should be.
Okay. So we've got,
I
and you
teach-
are what time at?
Like 5-ish.
Okay.
And I teach on Tuesdays and Thursdays, but in the morning, 11 to 12:45, so.
So we're looking at 5
After
o'clock
that.
any of these days. You all would be very smart to set a maximum time within which the hearing should occur. Because let's say you start it at 5. they can easily run 6 hours. I just got out of Henderson County for the, 2 weeks in a row, 1 day each, starting at 4, ending at 10. It's a hard day, it's a long day. The Board of Adjustment members were falling asleep. I mean, it's like, come on. So you all, if you're gonna set it at 5, you probably need to say, we're gonna preface that, we're starting at 5, we're gonna go no longer than 9. 4 hours is fine. That's a long day for everybody. Right, so any of those days, 24th is no good.
If it push came to shove, I'd have to move them, but I have an appointment at 4:30 that day. So, but the 25th through 27th is definitely much better for me. And I can start at 5 or
Yeah,
whatever.
25th through, if we could lock in the 25th through the 27th of that week, starting at 5, limiting it to 4 hours. Does that work for everybody?
Yes.
Sure. 25 to 27, 5 to 9, maximum.
Well, I guess if we're in the middle of something, we can run a little bit over, but we're gonna try to stop it at 4 hours. Right.
Certainly what will happen is you'll have a witness on the witness stand at 9 o'clock, and they'll say, all I have is 5 more questions. And those 5 more questions may last a half an hour, but that's gonna be up to you all to do it. And it may be 15 minutes before 9 o'clock, and they'll say, I've got one more witness, that's gonna take 2 hours. You'll say, we're done at 8:45. So it's gonna be entirely up to you all.
Okay.
It happens, you'll have to just play it by ear, but at the very beginning, the chairperson will, again, acknowledge, we're starting at 5 for these appeals, there will be a 4-hour time limit, and if we have to continue it, we will. And so as long as everybody knows, and I'll advise everybody on that too. All right, so that is January 25th through the 27th, starting at 5.
Each day.
Each day, but we're only counting on the first day, right? If these guys are fast, which they're not gonna be, we may be done in 4 hours, right? And then we don't have to worry about it. But if it's going to take 4 hours for each of these appeals, it's not gonna take 4 hours.
So
for
are we
each
gonna
of them.
carry over, or is
Yes.
it one separate? Okay, we're gonna carry them over until they're complete.
Yeah, there's 2 separate projects as I understand.
Right.
And again, we're not talking about the specifics of them, but it may be that one specific project happens on one specific day and then nothing else.
Right.
Whatever that appeal is, and then we'll go to another appeal. But that's gonna be up to the scheduling of the appellant, whoever that is in that appeal, and the developer or the property owner in that appeal. Just because they're the same attorneys doesn't mean we can just fluidly go from one appeal to the next, because it does involve different parties, there's different appellants, it does involve different pieces of property, it does involve different developers
Right.
and all of that.
And all those people are not gonna be here for all 3 of the days.
That I don't know, I don't know anything
Well,
about.
it'd be nice if
the
they were here waiting in
specific-
line, but.
Yeah.
Yeah.
I don't know anything about the specifics of who's gonna be here for what. We're
Well,
just
we
getting.
can't, can we say to them, these are scheduled to begin on the 25th, and they can all complete on the 25th, so if you're part of this organization, you better be there.
Yeah. they have to
Yeah,
be
so,
here.
so I'll work with
That's-
staff, what we're doing now is just getting the dates.
Right.
I'll be working with Shannon, or Ricky, to make a determination as to which one they're going to place first on what day.
Okay.
So that those parties will know they need to be there. And realistically, what I suspect will happen is the attorneys for these parties will say, oh, that day works better for me, can we have these appeals heard on that day? And as long as staff says, yes, we're prepared to go forward with that appeal on that day, you'll know that.
I would say, given the complexity of these cases too, I wouldn't think we would finish up one project set of appeals and move into another project set of appeals. We're not gonna be able to predict that, and so I think from a practical standpoint, we're probably just gonna tackle one particular project.
The project, right.
And then on a different day entirely.
Sure.
Move to the next
Okay.
project.
And I agree, and what I was thinking is if it's the same project with 4 appeals, that we might if they go fast, then why would we stop just because we didn't ask the person to be here, you know?
And the decision of one appeal could affect what happens with other appeals too, so we just don't know yet.
Right, okay.
No, but I agree. I will work directly with town to,
Organize them that way that,
yeah. Because again, I don't care about the appeals, I haven't looked at the appeals, right? I'm here to advise you all with your legal questions, but in scheduling them, staff knows, and they'll be able to tell me which day is a good day. Is that correct?
Yes.
I hope I'm saying that correctly.
And we're working with all of the parties, so
Yeah.
I think everybody will agree this is how we're gonna schedule
Okay.
this.
Yeah. So those are, so we'll lock those in, Shannon, if you've got those. Marie, those dates are good with you and Ricky?
Yeah, I'm blocking the council chambers now.
Okay, oh, right, yeah, there's no city council meeting or town.
No, it looks like they've got hold for something, but not,
We'll be
not
done.
during those times.
We'll be done.
Yeah, it looks like it's not, so I'm
Okay.
just blocking it out before it gets.
There are, they've got the January 30th, 31st, and the 1st. I don't know that I like any of those dates, that's right on the heels of 3 days in a row, have a weekend and come back 3 days in a row. If not, the 9th and the 10th of February.
What days are them? What day is that?
Friday, Thursday and Friday.
Thursday and Friday.
I'm good with those.
I can't do the 10th.
Brian, could we do like the 1st and the 10th? That's too far apart, I guess.
Yeah, likely too far apart, yeah.
31st and 1st, which gives 3 days in between.
Yeah,
Yeah.
January?
if we do that, if we do the 31st and the 1st, then it would be, would it be possible just to then get one other, like, oh my gosh,
The 9th.
date? Like just a single date floating out there in February in case it does take very long and we've got.
Maybe
one
the
more
9th.
deal to
The
get-
9th.
Since they threw the 9th out?
Yeah, so can everybody do the 31st and the 1st?
If it's after 5.
Yeah.
Yeah.
Same.
31st and the 1st.
Yes.
And then what's the 10th,
Back up.
February 10th? February 9th?
February 9th.
February 9th.
February 9th, 5 PM, just as the backup.
Can I ask you, I might have missed it when I first came up. Are we setting these, is this, I can't speak. These two, Richmond Hill and Robin Hood Road, those are the two projects, thank you. And so we're doing one project in January 25 to 27, and then the second project?
We don't
Or-
know when the first one will end, how many days it will need, so we'll just have to play it by ear.
But those are the only two projects?
We actually have one other application that may come off the agenda. We didn't get the permission for the Duke's. So we don't have any others CUPs, right?
I just have one request about
We have one other normal
Yeah.
application, for just an application, not an appeal, but it may come off, like, it may not need to move forward. So if that's the case, assuming that's the case, we just have these things.
Okay, I just wanted to.
Right, so you
clear
were,
about what
yeah,
we
you were
talking.
looking at that there were only, right, 2 projects, but one of the projects has 4 appeals related to it,
And the other one is two.
and the other one has 2.
Which one has the 4 and which one has the 2?
It's on your agenda.
I'm,
this top one.
this one is,
That one has 4 appeals,
I-
right? And so each one of those appeals is a different issue.
Right.
It's a different determination. And as Shannon said, one of those determinations may decide another one of the appeals. I haven't looked at any.
They could relate to each other.
Sure, they might not, they might all be separate, again, I don't know, but there's 4 of them, and so
Right.
there may be 4 different experts that testify on each one of them, it may be the same expert that testifies to each one of them, the appellant may wanna deal with each appeal separately, because it presents a different legal issue, they may wanna put it all together into one, but if it takes more than 4 hours, we're rolling into the next day. If it takes 4 hours and they're done, we can make a decision, and then if we want to, we can come back the next day and deal with the other 2 appeals. But as long as we have these dates blocked off and everybody is prepared and ready to come, we'll know that we can get through it. And then I'm just throwing out that last date as a backup date, just in case things fall
February 9th.
apart. And people get sick,
There's a
and,
blizzard.
yeah.
oh,
yeah.
God, yes.
So I have to assume for January, these will take place at the January meeting, since we have all these dates, and it goes right through the 26th as well?
It'll be in.
We won't have the 4th, or the next to last Thursday, or whatever we
Well,
normally...
that's the 26th.
Right, so January, this will kind of take place for...
Yeah, we'll advertise.
Okay.
For these dates, just out of an abundance of caution, just all 3 dates. And because that's also a little bit of a different start time, 5 o'clock's a bit different than what you want to do, so we'll get that out there. We do expect it'll be attended by members.
How does that work in terms of space if there are more people than will fit in here? And what's the occupancy limit?
It's right over top,
It's right-
96.
Ironically, 96. Now, you cannot fit 96
Yeah,
people
no,
in here
no way.
comfortably. We can get about 50 people in here
Yeah.
fairly comfortably, with a couple people kind of hanging out on the sides and
Yeah.
such. If we have a little bit more than that, we set up the conference room as a small overflow, so people can, and we'll stream it in there, so people can listen here, and then
Right.
some people move out and want people to come in. I don't think we're gonna need that much. I'm, maybe naively optimistic, but I think there's enough understanding in the community as to how quasi-judicial hearings work, so that, and maybe some people will just stay home and watch it.
Right,
We hope.
right.
We can all hope there's not a blizzard on those days. So, all right, well, that is set. I guess what I just want to also bring to your attention, remember, we did some training on standing, and I think, like, the statute, and I can pull it out, the statute basically says who has standing if you're the property owner, or the person appealing the decision, you've got standing, and the staff, town will have standing. I don't know if anybody else in the community is going to want to come up and seek standing. The benefit of seeking standing is that you become a party to the proceedings and you get to confront and cross-examine witnesses. You can make an opening and closing statement. You can present witnesses on your own behalf, whether it's just fact witnesses or expert witnesses, but you are able to fully participate. And so you may have some folks that, and this is on any appeal, we're just not talking about this one, this is on any appeal. You may have some folks that aren't represented that want to be made a party with standing so that they can participate. Your duty when you hear that is you're looking for credible allegations. They don't have to prove their case in standing, right? So you'll go through your agenda, and one of the things that you'll do is you'll open up an appeal case, and you'll say, this is a quasi-judicial hearing, only, evidence presented by the parties can be considered by this board. Are there, the applicant or the appellant and the property owner or the developer have standing, the town has standing, is there anybody else who thinks that they have or want us to consider them for standing? You may get 10 people, you just have to take their names down, swear them in, and it shouldn't take, you're not looking for an hour's worth of testimony. You're specifically looking for credible allegations about how this particular appeal will affect them separate and distinct from the rest of the community, right? They have to have these special damages, which are damages that aren't realized by the rest of the community. The courts have said it ordinarily amounts to a reduction in the value of your property or the free use of your property as shown by some external factor, whether it be noise, glare, odor, traffic. I mean, you can come up with a whole bunch of things, but you're not looking for them in the standing to prove their case. All they have to do is present credible allegations that they're going to suffer these special damages. So for instance, somebody may get up there, swear, and say, I live 2 houses down, so I'm not an adjoining property owner. But it's proposed that they're going to have this light at the top of their, or this sign at the top of their building, and we're appealing the decision to allow the sign because we say it's a prohibited sign. And that sign's going to shine glare on my property, in the window where I put my baby to bed, and the noise that's going to generate from the rooftop bar with the sign is going to carry to my baby's window, into my bedroom window, and it's going to prevent me from sleeping. And I am prepared to offer expert testimony from an acoustical engineer and an appraiser and a sign expert about how I'm going to be damaged. That would be enough, right? They've made their credible allegations of what they are and that they intend to prove it. If someone just gets up there and says, I live 7 houses down and all of that traffic's going to come by me because that's the only road that accesses it, well, as does everybody else in the community that lives on that road. So that's not separate and distinct from the rest of the community, likely not enough credible allegations of special damages.
So someone who's looking for standing has to have their people already with them. For example, the sign person, the traffic person, they
So
can't.
when you mean, when you're saying they have to have them with them?
Yeah,
Expert
here.
witnesses. She's
To-
referring to your expert.
Yeah, to
The expert,
testify.
I'm sorry, expert witnesses.
To testify, they do, right? But they, when they put on their case, that's
Yeah.
when they'll call their expert witnesses.
Right.
They don't have to prove their case when they're asking for standing.
The person, when they're trying to establish standing,
Yeah.
they don't need experts for that.
That's right, they don't need their experts to come up and testify. to
Okay,
that.
so they establish standing,
Yes,
and-
and they get to participate as a
and then they
witness.
participate.
Yes,
And don't they need to have the expert witnesses?
So they have an attorney,
Yeah,
and that attorney will, throughout that process, kind of pull in their expert witnesses at the appropriate time.
okay, so they need to be prepared.
no. You
Yeah,
got-
they need to be prepared.
They
yeah.
should be prepared.
Yeah, yeah,
Right?
yeah. You can't just get up and say, I want standing because, whatever.
You can do that, you can say I want standing. Standing isn't making a case
Right.
as to why you should rule one way or the other.
Right.
Standing is just saying, I am going to be.
I'm affected, I'm affected,
So
right.
therefore, I should be allowed to participate in this.
They want to be able to speak and say what they,
They want to be able to, it's not just speak, they
Right.
will have to present factual evidence.
That's exactly right.
Right, and so they do have to be prepared.
Yeah.
But that day, if you're like, do you have your expert here today? And they're like, no, that doesn't exclude them from having standing.
So when do you,
When-
what do we hold it in abeyance until they get the expert? I
So
don't understand.
standing, so you're blending the two issues together. There's a primary case.
Right.
Right, and that case is trying to prove X.
Mhm.
If I say, if X happens, I'm going to suffer some damages. So I want to be able to present my case against X.
Right.
And you believe me, I come forward with credible allegations to show that I should be able to participate because I'm going to suffer some damages if X happens.
Right.
Right? Then I get to sit at a table, or my counsel does, and I get to ask questions. When it's my turn to show what damages X will present, or it's my turn to show that X is the wrong decision, that's when I call my witnesses.
Okay.
And it may be on day 3 of a 3-day hearing
Okay.
that it would be my turn to have my experts there.
Brian is saying I might get to call my witnesses, as though the person who establishes standing is actually going to do that, but really what's going to happen is their attorney is
Yes,
going to
yes.
then call in the witnesses.
Okay.
And the attorney will probably ask the person who is now established to have standing will ask them questions to help explain what their concerns and issues are.
If we're traveling through that particular issue, appeal, whatever, at a fast enough clip, and we're going to finish it that evening,
Yeah.
and your expert witnesses are not here,
Out of luck.
Out of luck.
that's the
Okay.
answer that.
So
think
then
that's what she was
they
asking.
need to be prepared.
It would be wise for them to have their expert witnesses.
It would be wise for them to have them, but
Right,
you cannot
right.
exclude them from gaining standing if their expert
Okay.
witnesses aren't sitting in the audience.
Okay, all right. That's-
So, okay, you've got standing, all right, let's hear your case. Oh, I don't have my expert
Yeah,
witnesses.
well
Oh,
then-
Well, then you don't have a case.
That's right, yeah, you've got standing, but you don't have anything to prove. We're not gonna hear anything.
Is it acceptable to put kind of time restraints on how long somebody
Yeah.
can talk? Because we know sometimes people keep saying the same thing over and over, and 30 minutes can go by.
So,
They've kind of said what they need to say, and we can move to the next step.
I think you might be talking about like just public comment, somebody wanting to come up and yammer on and on and on. That's, again, separate and
Kind of a
distinct
thought that came up while.
from,
Yeah.
separate and distinct from the case. This, the Board of Adjustment, acting as a quasi-judicial board in hearing this case, does not
Right.
have to allow
Right.
public comment.
Okay.
Right.
You do not. And I will say about half of the boards in Western North Carolina do not allow public comment. The other half does. And the other half that does allow public comments afterwards limits it to 3 minutes. The problem that you have with allowing public comment after a quasi-judicial hearing is it's not evidence, right? Because they're not parties withstanding. They don't have the ability to do it. And you can't consider it, you shouldn't consider it in making the determination of your case. But a lot of times, the people that come up and want to talk for 3 minutes are very powerful speakers. They're very impassioned, and you're like, oh yeah, that's an excellent point. But guess what? It's not evidence. You can't consider it. And it may sway you one way or the other to make a determination like, remember, John Q. Public came up.
It's like ex parte conversation in my
Yeah.
mind.
So we're better off not allowing
not
public
allowing
comments.
it.
Right, you know,
I think so.
right,
I think so,
I'm
too.
not gonna say anything.
Yeah.
Um,
Well-
you
well,
know,
like
and the town manager
Yeah.
may
Yeah.
want it a different way, or the town attorney may want it a different way, but it is very hard to sit through 45 minutes of 15 people, 3 minutes each,
Right.
talking
Right.
about this issue, and then not have that
Right.
affect
Right.
what you're thinking.
Right.
Along these same lines of this question, it would be inappropriate to, and so I'm guessing we should not or cannot, have any kind of a limit of time for testimony, correct?
So there's a court opinion out there that says if you're gonna do it, right, it can't be unreasonable, and then you have to limit everybody to that. And
Okay.
so my advice is, don't even start with saying, okay, Mr. Appellant, you've got 2 hours to put your case on, you, other side, you've got 2 hours to put your case on, rush through it. Let them put their case on, let them call their own witnesses.
Yeah.
If you all decide that you know what, we've heard this before. This is your third witness that you've called to say the same thing. Mr. Chairman, you could say, if you don't have new evidence to present, we've heard this before, please call your next witness.
Good,
Okay, good.
okay,
You can do it.
good, okay.
That was kind of my thought on my earlier question too, was when things keep getting repeated over and over and over, and it can be drug out for a while.
And-
I don't think you're gonna experience that. It's not gonna be like a conditional use permit for a asphalt plant where like 1 million people show up and they're all
Right.
want their 3 minutes.
Right.
There are boards of adjustment who let people do that, but we would not want you to do that.
Right.
We don't want, I mean, if you don't have standing, there's no need for you. That's why I'm saying, like, I hope we won't have a huge crowd and.
Yeah,
people
yeah,
sit there
really.
and Watch it because they don't get to participate.
Right.
They're just gonna be watching.
Yeah.
Okay.
And they understand, they will understand
We're doing
that
our
they
best
can't
to kinda get
participate.
that out there. I mean,
There's not gonna be a list where they sign up and say, I wanna say something. Okay,
I mean, they have to actually, there's a form that we make them fill out to the staff, like, tell us why you
Right.
think you have standing.
Right.
and,
Okay.
and then
Okay.
that gets reviewed.
which is different than, right,
Yeah, which is different
other
than
meetings
just a
that, yeah,
Legislative public hearing. Yeah.
okay. Gotcha.
Right, this will be a public meeting, it will not be a public hearing where community members can come and just yammer.
Yeah, yeah.
Very specific, you
Yeah.
all treat it as if it's a court case. Now, the rules of evidence loosely apply, right? So if someone is objecting on some specific rule of evidence 8.802, like, you're like, what the hell does that mean, right? Who knows? But they loosely apply, but if you want to hear some evidence, if you think it's going to have some kind of weight, let it in, and then if you're like, oh, that was crap, you don't have to give it any weight at all,
Okay,
right? So you can make a determination as to whether the evidence comes in, and then you can decide whether to give it a lot of weight, a little weight, or no weight.
okay. And so, when we finally make a decision, it's a decision that the only way they can refuse to accept it is if they go to court? I mean, are
Well,
we,
they don't refuse to accept it,
mean-
you all make your decision,
yeah, yeah,
right? And if they don't like it.
and they
can
don't
appeal
like it. And they appeal it, but not with us anymore.
No, it goes up to Superior Court.
Superior Court,
We are
okay.
the appeals court for the
We are,
township.
for the
You
town.
all, on this appeal, are the first place where an appeal from a zoning determination comes to you all,
Right,
right?
okay.
And you all, again, you weren't here, but you all step into the shoes of the zoning administrator. And the statute says that you can affirm or deny, wholly or in part, or you can modify and make your own decision, right? So you've got the ability to affirm it in whole, deny it in whole, or come up with a different decision.
Okay. And is someone going to escort us out to our cars?
Please.
I know. Look
So,
at it.
that,
Okay,
yep, that is it, that's an appeal. That is really what it is. You all have to know and understand what your zoning ordinance is, and then you take the facts as you gather them from the evidence presented, and you apply that to the zoning ordinance as you all interpret it. And you all may interpret it differently, and that is good, right? That's good for debate or discussion. And once the hearing is closed, I will say this, once the hearing's closed, don't ask anybody else, oh, by the way, do you have the ability to do this, or could you do this if we
Yeah.
rule this way?
it's done.
Done.
It's done.
It's, the deliberations is in front of everybody, but it's behind this invisible cloak. You can't ask for any clarification from anybody. You can ask questions before the hearing's closed, so you better ask all those clarifying questions.
During the deliberations, when that's closed to everyone else, how about you?
Oh, yeah, you can absolutely ask me questions, and you can ask any of the board members questions.
Okay.
Okay,
But nobody else. And because the town staff will be a party to that proceeding, can't ask them questions either.
okay.
What about just clarifications? Is that okay? Like, what was the date of that? Or
Well,
Well, we can ask the attorney, and the
Yes.
attorney can decide.
Yeah,
Right?
that's true.
yeah. The idea would be no, right? Because it's completely closed. If you all were jurors going back, you could ask the judge, hey, what was that date? And then they may go and ask the, the plaintiff and the defendant. But really, you're not. I get very upset when boards of adjustment start again talking, because, you get the camel's nose under the tent. And it goes, was it June 6th or July 6th? Oh, it was June 6th. Was it at 11? And what did you say again? Was it behind the house or in front of the house? And then it just goes, and then, then you're in. So,
Okay,
9 PM becomes 11 PM.
yeah,
yes.
thank you.
So, you won't know anything for the next, 2 or 3 weeks about when it will actually get set and which appeal is going to happen. But if we've got these dates locked in, I think we're all good.
Okay.
Can I ask a question?
Yes.
You can go if you want to.
No, because we
The
have to,
bluffs-
still we have to adjourn.
Oh, the bluffs, that's the thing where, is on the other side of the river, right, where the guy was gonna build the bridge. Yeah, okay, I just wanted to be clear about that. And the Robin Hood Road,
So, above the country club.
where's the country club? Is there a country club in Woodfin?
See, so you are perfect right now. Don't go investigate,
we're
don't
allowed
do anything else.
Okay.
You will hear all of this.
Oh,
evidence. It
okay.
will come to you through
So
your
I need
staff report
to, I
and a
need to
packet.
wait to have it be.
Because I asked that question at the beginning, we're not supposed to know
Oh,
that.
we don't wanna know that, okay, okay.
Yeah, I mean, it's out there, there's been enough conversation.
Oh,
Yeah,
God.
and I will say, you all are not prohibited from going to visit any of the sites, right? Don't talk to anybody about it, don't
Right.
listen to what you hear on the
Right,
street.
right.
Right, you can go and visit the site, but anybody that talks to somebody or tries to talk to you, or if you receive a letter, the statute requires that you disclose it
Right.
at the beginning of the hearing. And I think that, and I can work with Shannon on making sure that we create maybe a protocol that we go through all of these things. Anybody have ex parte communications? If so, what was it, who it was? Because that's what you have to do. You have to disclose it. It would be up to the attorneys for the parties to make a decision as to whether or not you can be fair and impartial, or whether there's a conflict of interest and they want you to recuse yourself.
So would we be able to review the original application that went before the planning board, or we're not supposed to look at that either?
If that comes in your
That's what I was-
record?
No, I mean, we can't ask Shannon for that.
No,
Okay.
no.
Okay, that's what comes in that record.
Yes,
Okay.
yes, it may or may not. That's
may.
right.
Okay.
It'll be like Christmas all over.
But yes, that is correct. That is, you're correct.
Okay.
All right?
Anything
Yeah.
else?
Any other questions?
I make a motion for adjournment.
Second? So moved. Meeting adjourned. Thank you.
Thank you.
Yes, you bet.
Put these in my calendar right now. Don't have them.
Okay.